Judges overturn Asylum hotel interim ban. 6 reasons why the government won. The Court of Appeal judges have overturned an interim ban on using a hotel in Epping, Essex to house asylum seekers. So why did the government win this stage of the court process? Was this a fair legal decision and correction, or another case of local people being ignored? Let me break down what happened, what the High Court said, what the Court of Appeal said, and what it means for the rest of us. Let me separate fact from fiction and give you my personal view at the end. I will be referring to the summary of the judgment of the Court of Appeal, as well as the High Court judgment, which you can find in links in the comments section. What you will find is that there were 6 reasons why the government won this stage of the court battle to house asylum seekers at the Bell Hotel. If you like this content, please subscribe and follow for more, and feel free to comment. Let me start with the High Court ruling, what it decided and why. On the 19th of August, Epping Forest District Council won a temporary injunction in the High Court to stop the Bell Hotel, owned and run by Somani Hotels, being used to house asylum seekers. The full hearing to determine whether there should be a permanent injunction is to be decided in October 2025. Now, the impact of the temporary injunction granted by the High Court would mean that all 138 asylum seekers currently resident at the hotel will need to be relocated by the 12th of September 2025, pending the final hearing in October. See paragraph 23. The legal test for whether an interim injunction should be granted in England and Wales comes from the House of Lords case of American Cyanide Company versus Ethicon Limited 1975, which is a 3-part test. Step 1. Is there a serious issue to be tried? The claimant doesn't need to prove they'll definitely win, just that the case isn't frivolous or hopeless. The merits of the case are to be decided in that October hearing. In the Asylum Hotel case, Epping Council's planning argument cleared this low threshold. See paragraph 36. Step 2. Would damages be an adequate remedy for the claimant if no injunction is granted? The dispute between Epping Council and Somani Hotel was about planning control and community impact, not something easily fixed with money. And step 3. Where does the balance of convenience lie? This is the key step. If there is any doubt as to the adequacy of damages for either the claimant or the defendant, the court must then weigh the balance of convenience. This involves considering the likely harm to the applicant if the injunction is denied, the likely harm to the respondent if the injunction is granted. The court will try to maintain the status quo, the existing state of affairs, if other factors are evenly balanced. Now, the High Court judge's reasoning to grant an interim injunction, applying the 3-part test, particularly that balance of convenience part, came down to taking into account 2 or 3 main factors. See paragraphs 108 and 109 of the High Court judgment. Firstly, breach of planning laws, paragraph 108. The council argued that turning the hotel into a long-term accommodation to house asylum seekers was a material change in use and therefore needed planning permission, which according to the council, Somani didn't get. The judge agreed and took that into account in the balance of convenience in support of the grant of an interim injunction. Secondly, local impact of housing asylum seekers in the Bell Hotel. What was being argued by Epping Council is that there had been serious protests outside the hotel, sometimes violent, and the arrests of both protesters and a handful of residents for alleged crimes. In fact, as noted, counsel for Epping that the protests operated as a trigger for the application for an injunction, paragraph 39. There was local public fear of crime and the loss of amenities. The High Court judge said those fears carried weight and were relevant in favour of granting an interim injunction. Now, crucially, the High Court refused to allow the Home Secretary to be party to the case, denying the government an opportunity to make representations at the High Court. Paragraph 21. In a short oral judgment, the judge gave the reasons for refusing the Home Secretary's application for party status. In short, he concluded that it was not desirable, a term used in civil procedure rules, for the Home Secretary to be a party to the litigation. It appears that the High Court judge treated this case as a dispute between the council and the hotel operator, not the government. That meant the Home Office, the department responsible for housing asylum seekers, was effectively sidelined at this interim stage. Now, let me turn to the Court of Appeal, why the government won and overturned the temporary ban. The government and hotel appealed the High Court decision to grant a temporary injunction in favour of Epping Council. In its ruling, the Court of Appeal made two decisive moves. First, the Court of Appeal said the Home Secretary should have been joined as a party in the High Court proceedings, and excluding the Home Secretary was legally wrong. This part of the Court of Appeal ruling is found in paragraphs 25 to 33. Among the reasons given by the Court of Appeal why the Home Secretary should be joined are because she, the Home Secretary, has statutory duties to house asylum seekers to prevent destitution and to manage public order and safety. See paragraph 27. Now, secondly, the Court of Appeal found the High Court balance of convenience at the interim stage was flawed in principle. You can read this from paragraph 36 onwards. Here, the Court of Appeal set out 6 clear reasons why the balance should be in favour to the Home Secretary and Somani hotels to continue to house asylum seekers in the Bell Hotel and to overturn that temporary ban, that temporary injunction. Let me now outline those 6 reasons why the judge overturned the temporary ban. And I'm referring to paragraphs 36 to 47 of the Court of Appeal summary ruling. 1. The wider picture is a national system, not one hotel at a time. Paragraph 37. Asylum accommodation is part of a national system. The Court of Appeal was saying that shutting one hotel just moves the pressure elsewhere and risks dozens of councils rushing to the court for an injunction. The High Court didn't address this wider impact. Paragraph 37, the judge's approach ignores the obvious consequence that closure of one site means that capacity needs to be identified elsewhere in the system and may incentivize local planning authorities who wish to remove asylum accommodation from their area to apply to the court urgently before capacity elsewhere wherein the system becomes exhausted. 2. Incentivizing protests. In other words, the Court of Appeal said the interim injunction would serve to incentivize disorder. Paragraphs 39 to 40. Protests outside the hotel were one reason the council acted. The High Court factored those protests into its decision to grant an interim injunction. The Court of Appeal said that was wrong and was a worrying aspect of the judgment. What the Court of Appeal was saying is, if protests lead to injunctions, you risk encouraging more unrest, not less. Protests should be managed by policing the public order through public order laws, not court orders shutting hotels. Paragraph 38. 3. The council's own delay. Paragraphs 41 to 43. The hotel had been used for asylum seekers before without enforcement action being taken. A planning application sat undecided for a year. The operator, Somani, wrote to clarify in May 2025. The council never replied. Then came the council's 1,600-page bundle, dropped right before the court. The Court of Appeal judges said such delay undermined any claim by the council for urgency for an interim injunction to ban housing asylum seekers. And that tactic by the Epping Council was procedurally unfair on Somani. This was a significant factor in the balance against an interim relief, that interim injunction. 4. The High Court was wrong to say Somani deliberately breached planning laws. See paragraph 44. The High Court concluded the operator Somani of deliberately ignoring planning laws. The Appeal Court said this was wrong. Somani, the operator of Bell Hotel, had tried to regularise things with the council. That criticism by the High Court was wrong and unfairly tilted the balance of convenience. 5. It was only a short-term injunction, see paragraph 45. Forcing 138 people out by the 12th of September, when a full hearing was scheduled in October, made little sense to the Court of Appeal. The High Court gave too little weight to keeping things stable until then. And 6, the balance of convenience was seriously flawed, see paragraphs 46 to 47. As a consequence, the Court of Appeal said the High Court balance of convenience was seriously flawed. Yes, fear of crime is relevant, see paragraph 47. But then it goes on to say, we agree that it is relevant, but in our view, is clearly outweighed by the undesirability of incentivizing protests and by the desirability in the interest of justice of preserving the status quo for the relatively brief period leading up to the forthcoming trial, and by the range of public interest factors which we have discussed in our judgment. For these reasons, the temporary ban was overturned. The government's relief at the ruling should not be understated. For the Home Secretary, the Home Office, this ruling is a big relief. It avoids the immediate crisis of moving 138 people and others potentially, and undermining the national system of housing asylum seekers. But it's not a total victory. The planning case still goes to full trial in October 2025. And politically, it's a bad move and bad optics on behalf of the government. Central government riding roughshod over local people's concerns. So what's really at stake? This case represents, on face value, local councils and sections of the community versus central government duties. Now, in my opinion, the Court of Appeal's decision on the interim injunctions was legally sound. The High Court made errors of principle and got the balance of convenience wrong. But politically, the ruling deepens divides because the real and underlying problems remain unaddressed. Slow asylum decisions made by government, swift removal of failed asylum applicants from the UK, asylum seekers risk being scapegoated for the ills of society, asylum seekers unable to work to pay their own way, the chronic housing shortage due to successive governments' failure to build houses, years of underfunding of local services and amenities, local people feeling ignored, the impact of Brexit and the inability to control borders, distraction politics, warfare spending over welfare, and the growing intolerance of the other being normalised by certain media and political commentators. Until these and other issues are fixed and addressed, cases like the Bell Hotel will keep ending up in court and used and misused to promote particular media and political agendas. So to conclude, the Court of Appeal judges overturned the temporary ban to stop asylum seekers being housed in this hotel, and the government won the appeal because national duties preserving order and stability outweighed local concerns and the fair and planning objections. But do you agree with the Court of Appeal's reasoning, or should local councils have had the final say over an interim injunction? In the end, we will have to wait for the October hearing to find out the eventual outcome of this case. Will they grant an injunction or not to stop asylum seekers being housed locally in this area? But what do you think? Feel free to comment, subscribe, follow, like, and share.